All right, welcome back to Triple P, the Parallel Proceedings podcast, where we explore how individuals and entities manage the complicated world of parallel investigations and prosecutions. I'm Kevin Muhlendorf. I'm a former federal prosecutor and SEC enforcement attorney, and most recently I spent nearly a year as the acting inspector general at WMATA, our metro transit system here in the DMV. In my day job, I'm a partner at Wiley Ryan in our white collar and government investigations group and lead our securities enforcement practice. In episode 1, we talked about the basics of what parallel proceedings are, why multiple government agencies are allowed to simultaneously investigate the same behavior, and how that can affect those under investigations. But you really can't understand the situation without trying to understand what the government enforcers are thinking. To that end, today we have a really fantastic guest who has done it all in the world of parallel investigations. Brian Young, who currently serves as director of the Commodity Futures Trading Commission, the CFTC's Whistleblower Office. Brian, I want to talk about your present role as the director of the CFTC Whistleblower Program. You gave us a little bit about the basics in the first episode. But first, I want to touch on something that harkens back to your time in the Civil Division of DOJ. When I deal with whistleblowers and explaining the various programs, the CFTC or the SEC, I run into people who get a little confused about the difference between those programs and the False Claims Act and qui tam whistleblowers. Can you explain conceptually what the differences are and how they operate?
Sure. I think the biggest difference between, I'll call it Dodd-Frank programs, and that's the CFTC and the SEC, and the False Claims Act, is in a False Claims Act case, the whistleblower initiates the matter by filing a complaint under seal with the local United States District Court. So it starts literally with a complaint and a court filing. In the Dodd-Frank whistleblower programs, such as SEC and CFTC, you initiate your complaint by filing a tip with the administrative agency, not with a court. Another really decisive difference between the two programs is in the False Claims Act, the whistleblower can pursue that case as a private attorney general, as they say, even if the Justice Department decides they don't want to take it on. In Dodd-Frank, if a whistleblower files a tip, they are reliant on the agency to either take the case and bring it themselves. If the agency declines the case, then there is no recourse. The person cannot pursue their own regulatory action. And I think as far as the substance of the matter, for the SEC and CFTC whistleblower programs, in order for the whistleblower to recover, the agency needs to establish a violation of their statutes. In the CFTC context, that's the Commodities Exchange Act. For False Claims Act, the whistleblower needs to prove that the federal agency was essentially defrauded. And so it's just a different scope. And those are, I think, the primary differences between the two programs.
Yeah, and I think one of the things, and you sort of alluded to this, is the way that a whistleblower proceeds under the two programs. I mean, one of the things that I find confusing to people is when you talk about an SEC or CFTC whistleblower, they're really handing it over. You know, they present information to the agency and the agency runs with it. Whereas in a qui tam or False Claims Act situation, there's the potential that the whistleblower is going to have to litigate to recover. And I think that's a big difference that people looking at these cases don't sometimes appreciate. That it's much easier, I think, to be, in some ways, to be a Dodd-Frank whistleblower than it is to be a qui tam whistleblower.
I think it's probably a little less labor intensive to be a Dodd-Frank whistleblower because you're not a litigant in the case. When you are a False Claims Act whistleblower, you are literally a party to the case. Your name is on the caption. So, you don't have to worry when you are a Dodd-Frank whistleblower about actually litigating. The other side of that coin is a False Claims Act whistleblower has a little bit more control in shaping where the case goes, and they have a little bit more input on how the case unfolds than a Dodd-Frank whistleblower whose only option is to provide information to the regulator and see what they do with it.
All right, let's turn back to the basics of your program at the CFTC. Who is a whistleblower? What types of cases are there? And what does it mean to be anonymous? And how do you get an award? I can go through those one by one, but so who can be a whistleblower for the CFTC?
Almost anybody can be a whistleblower for the CFTC. That would exclude people who work for a government agency. So if you work for the FBI or something and you learn of a case, you can't tell the CFTC about it.
Yeah, makes sense. It's sort of your job anyway.
Yeah, it's your job anyway. You also cannot receive a whistleblower award if you have a criminal conviction related to the conduct that you are reporting on. A whistleblower essentially can be anybody else other than those types of people. And the touchstones are you have to provide information voluntarily, and you have to provide information that is, I'll just say, helpful. That's not the legal term of art, but it has to be original information that helps the CFTC advance the case.
So that's actually an interesting point, original information, because I always like it has to be helpful, has to advance the ball. But also, I noticed one group you didn't absolutely exclude were sort of compliance officials, attorneys. I mean, there is room in there for people like that to be whistleblowers and recover, but I think they have some more hoops to jump through, right?
That's right. A compliance person can receive a whistleblower award. And we've had, at least since I've been there in February, we've had 2 press releases announcing whistleblower awards to people who had either compliance or audit functions. But there are more hoops to jump through, as you said. If you have an internal audit or compliance function, you need to report that internally at the company and then wait 120 days at least to file your whistleblower tip with the CFTC. The other thing that's important is original information cannot be attorney-client privilege information. So somebody cannot come and violate their attorney-client obligations to the client, get disbarred, probably, and then give us that information. And if the CFTC recovers, then that person is not entitled to a share of that information.
Yeah, I think there's a provision, at least in the SEC's rules, that talks about how attorneys can do it and that the SEC takes a position that's not a waiver, but I've never really understood that.
I guess the way I would look at it is you're not certainly categorically barred from being a whistleblower because you are an attorney. You cannot reveal attorney-client communications. However, you could, if you sat down and thought about it and were careful, there could be a way for an attorney to communicate the substance of a violation without communicating attorney-client privilege. You could say, I can't give you my communications, but you should talk to A, B, and C. And maybe there's a way to negotiate that.
Yeah. What I've often told when we teach this in our class is that I know what the rule says, and I know there's supposed to be a way to navigate it. I don't think it's actually been litigated about how close you can get to that line. I think you'd have to have independent counsel to advise you on that before you did it. I think it would be extremely difficult and dangerous
you'd have to proceed very carefully. You would not be categorically excluded, but nobody wants to use a whistleblower program to give an incentive for lawyers to violate, their duties of confidentiality. That's not what we're trying to do here. I mean, we are trying to avoid it, in fact. And so if an attorney was thinking of becoming a whistleblower, yeah, you'd be well served to get another lawyer to help you out and give you advice.
Now, you talked about this already, about what types of cases, so we'll skip over that. I mean, for your program, it has to be a violation of the Commodities Exchange Act, right? Is that
That's right. And I guess if I had to simplify it as much as I could, people say, well, what does the Commodities Exchange Act cover? And there's a lot to it. But if I had to break it down, I would think about it in asset classes. So if you're an attorney, you're a potential whistleblower, you're wondering whether what you observe falls within the reach of the CFTC, my first analysis would be asset classes. And that is foreign exchange, precious metals or base metals, certain types of digital assets, crypto. I can't get into all of it today, but generally, if it's fungible digital asset, more likely to be a commodity. Certain financial products linked to a benchmark, so a swap or anything related to a financial benchmark. Agricultural products, so like soy, oats, wheat, cattle, anything like that, those are considered commodities. And if you are dealing with those asset classes, that's a pretty good hint that you're going to fall within the CFTC program.
Okay. And so then let's assume that you've got the right type of case, you're the right type of whistleblower. Can you be anonymous? Can you hide who you are?
You can. A whistleblower can file anonymously, which is to say that they don't reveal their name. And that typically happens when the whistleblower will retain counsel. Their lawyer will then file the TCR, which is the form that you use to make your tip. They'll file a TCR. The lawyer identifies him or herself, and that is how we know who they're dealing with. The person Whistleblower can then remain anonymous up until the time if they get an award. At that point, we need to know who it is, because you have to ensure that it's not an FBI agent or somebody who should not be receiving money for other purposes.
But even if it's whether you're anonymous or not, the CFTC, I assume, takes some precautions to protect its whistleblowers, right? I mean, because obviously they put themselves at risk. So
we do. I mean, it's part of the attractiveness of the program is that we try to preserve somebody's confidentiality, because we understand that you don't want your employer to find out and get jammed up on that. And we go to great lengths to preserve confidentiality. I think the largest exceptions to that is legal discovery, meaning if you have a tip and then your tip becomes information that we or the Justice Department or somebody need to provide as a legal matter as part of a court case, well, in that instance, we would have to disclose the whistleblower's identity. But it's fair to say that we go to great lengths to avoid having to out a whistleblower.
All right. And so you've jumped through that hoop. You made an anonymous submission or a confidential submission. It's a CEA case. What kind of money are we talking about here?
The statute allows a whistleblower to recover somewhere between 10 and 30% of the civil monetary penalties that the CFTC collects, I should say, as part of its matter. So if there's a judgment of $100 million, but the CFTC only collects $5, the award is based on the $5. Having said all that, I think you can take a pretty quick look at our press releases. You could see whistleblowers have received really big awards, and that's because the derivatives markets that the CFTC regulates involve a lot of money. And so the resolutions can be really big. And 10 to 30% of some of these resolutions can add up to a lot of money.
Yeah, I actually saw some statistic somewhere back in my head somewhere about the nominal value of the markets you guys regulate is so much greater than what the SEC regulates, but you're so much of a smaller agency. No one really thinks about that, but because of the way that the markets work, but it's vast, right?
Yes, it's a huge regulatory mandate. The CFTC is not a particularly large organization.
All right. So last question I'll ask you about the way whistleblower awards work. What about related actions? I mean, so what if the CFTC doesn't recover anything, but DOJ whacks someone for $100 million?
Sure. There's a concept called a related action that you mentioned. A related action is when, let's say, a whistleblower files a tip. The CFTC then goes forward and they undertake an investigation. If they give that tip to somebody at the Justice Department, and the Justice Department recovers, let's say $100 million, and part of that tip, part of the recovery or their case was based on a whistleblower's tip, then that's considered a related action. What that means is that whistleblower, if they're otherwise qualified, get between 10 and 30%, not just of the CFTC's recovery, but of the Justice Department's recovery too.
Okay. And so that means, though, that they have to file with you guys, though, to be eligible.
Yes. The whistleblower has to file first with the CFTC to be eligible. That's number one. And the CFTC needs to make a recovery based on that tip. That's number two. And if the CFTC gets a recovery based on that tip, and so does the Justice Department or some other enforcer domestically, then that's considered a related action. What you can't do, though, is let's say you provide a tip to the CFTC declines that case. There's no action that the CFTC takes, but nevertheless sends that tip on the Justice Department, who recovers $10 million. The whistleblower is not entitled to receive any portion of that $10 million because the precondition is that the CFTC has to be successful in its action.
Well, and so that raises a really interesting question that I don't think we have time to explore here, but we may do it in a subsequent podcast. You know, the DOJ just came out with their own whistleblower award program, this pilot program, and it talks about cases where it's supposed to be where other agencies you can't recover under another agency, and whether if you get declined at CFTC, does that mean you are eligible for the DOJ program? And I'm not asking you to opine on that now because I don't think we know the answers yet, but it is sort of an interesting concept. All right. Since I mentioned the DOJ program, and this seems to be hot on with DOJ's, they just released some guidance on corporate compliance programs, but also their whistleblower award pilot program. One of the things that's been in the news a lot is whistleblower retaliation and protecting against that, and what companies need to do to make sure that they're doing the right things in their employment manuals and things like that. The SEC has been really active in this space under their Rule 21F17A and issued a lot of fines and settled actions for impeding whistleblowers. We've written a lot of client alerts about that here because it's sort of expanded to, they did one recently that was a supplier agreement, and which I thought was really interesting. It's getting one step removed, I think, from typical whistleblower impedance stuff. Does the CFTC have similar rules, and have you guys brought enforcement actions along those lines?
Yes, we do. And I guess what I would point to is the CFTC's regulations on it. And if you go to the CFTC's regulations, which you can find, I'm trying to find something online for you. But in any event, if you go to the CFTC's regulations, it's Part 165. Okay. In the Code of Federal Regulations, 165.19. And what that says is a company, or really anybody who falls within the CFTC's mandate, can't impede an individual from reporting information to the CFTC. All right. If you take some measure to impede an individual from reporting to the CFTC, then you could be in violation of the regulations. What does impede mean? I can't speak for the agency. I can't speak for the entire CFTC. I can tell you how that word hits me. And I think impede means something, it can include more than just an express directive. Like if you tell the employee, you may not report anything to the CFTC, right? That's an issue. But I think impede would go further than that to include things that really discourage an employee from reporting to the CFTC. For example, you have to jump through a lot of onerous and unfair hoops. You have to do something that is going to put you in jeopardy with the company.
Yeah, or I think the SEC has even said that if you, for example, a lot of the cases in the group that just came out talked about you can't recover a whistleblower award. That was impeding. So if you require employees to waive that, that was impeding.
Yes, and that's, if you look at 17 CFR 165.19, that's the regulations I was talking about, that makes that pretty clear. A person who falls within the reach of the CFTC's regulatory ambit cannot tell an employee, look, you have to agree never to receive a whistleblower award. There are also retaliation provisions, the anti-retaliation provisions. Those are in the statute itself, in the Commodities Exchange Act itself, which is Title 7 United States Code 26H1. And what that says is no employer may discharge, demote, suspend, directly or indirectly threaten or harass, or in any other manner discriminate against a whistleblower in the terms and conditions of employment because of, and then end quote, what amounts to protected whistleblower activity. So the company cannot retaliate against somebody for taking whistleblower activity. I think one thing that's also probably worth noting is the person doesn't need to actually recover. You don't have to be a whistleblower in the sense that there's a successful case in a recovery in order to have the benefit of these protections. If you report, that alone can trigger the whistleblower protections.
All right. Well, it's a lot for companies to think about as they design their compliance programs. All right. So I think that's going to wrap it up for questions for you, Brian. Is there anything else you wanted to throw in there at the end? This has been such a great conversation. I hate to cut our listeners, deprive them of your time. But is there something else I didn't ask you wanted me to ask? That's a question prosecutors always ask at the end of an interview.
Is there anything I should ask? I'd offer two things. To people who are thinking about being a whistleblower, I would suggest that the program is attractive because it has very robust confidentiality protections. Not 100%, but they're pretty robust. It can also be lucrative. You can make a lot of money if you get between 10 and 30% of a big award. And, it could be a public spirited thing to do. You could bring to the attention of a regulator a problem that they could fix that wouldn't otherwise get fixed. If you're a company and you're dealing in a space that's regulated by the CFTC, I hope that the whistleblower program creates an incentive if you find a problem to do the right thing to resolve it. Because you make a decision in your company that you're not going to report that conduct to the CFTC, but a whistleblower may do something else. And so the agency may find out about conduct that the company knows about, even if the company doesn't intend for the agency to know about it. And the company is usually better off, in my experience, almost always better off, coming to the regulator or the enforcer first before a whistleblower beats them to the door.
Yeah, this is always the question, right? The self-reporting question, which we're going to cover in another podcast, how to deal with that. Well, thank you. That's great advice. I mean, we spend a lot of time here at Wiley, advising our clients on how to design their compliance and ethics programs. And that's actually one of the issues is the whistleblower reporting regime and how you deal with that and how you handle internal reports and how you track them. And now with DOJ's program, a whistleblower pilot program, you've got this, you mentioned 120 days. That seems to be the time frame everyone uses. DOJ has come out with this 120-day clock for self-reporting when a whistleblower is already reported internally.
Can I tell you anecdotally, too, when I got to the CFTC, I was surprised at how many whistleblower complaints involved people that raised the matter internally, even not compliance people, before going to the CFTC. It's relatively rare that people just run to the regulator first. And so in many of these, and I don't have numbers on this, but anecdotally, in the tips that I'm seeing, the companies are in a position to deal with it before the person comes to the CFTC.
That's really interesting to hear because there are studies that show that. It's really interesting to hear it from your point of view. That's what's going on. And it really does get to the heart of what good compliance professionals should be doing is making sure whistleblowers felt heard. And you may disagree with what the whistleblower is saying, and you may not be able to explain why, but often we find that if the whistleblower feels like the issue is being dealt with and they're being treated fairly, then they don't go externally because they feel like the company's handling it. And you seem to be kind of confirming that. It's the people that don't, where it's not handled, that they run to you.
That's been my experience. And I think some people perceive whistleblowers as being motivated primarily by money. And to be clear, the program does provide a financial incentive. But at least in my experience, seeing the whistleblowers I see and reading the tips I read, I don't think these people, for the most part, are motivated entirely by money. And they do a lot of times report internally. And if somebody reports internally first before rushing to the agency, to me, that suggests that the financial reward isn't the only thing that's motivating them to report.
All right. So that's just tremendous insight. Because we broke up the episodes, we've got some new and late-breaking news from the parallel universe. Yesterday, October 2nd, the SEC announced that the current director of the Enforcement Division would be stepping down on October 11th. According to the SEC's press release, in 3 years at the helm, Enforcement Director Gabir Gurwal supervised 2,400 actions, resulting in $20 billion in disgorgement, interest, and penalties, and more than $1 billion in awards to whistleblowers. 100 of those 2,400 actions involved crypto. Gurwal is going to be replaced by the now current Deputy Director, Sanjay Wadhwa. What this means for the Enforcement Division's program going forward remains to be seen as we await the change in administration and perhaps a new chairman at the SEC who will then get to select his enforcement director. And finally, as always, if listeners out there have any questions, comments, or concerns, let us know. If you send me a question and we answer it in the next episode or one of the next episodes, we'll send you some super cool Triple P swag. Brian, I can't thank you enough for coming on Triple P. This is the #1 podcast on parallel proceedings, and you are our #1 guest so far. So we really appreciate you being here. This has just been a tremendous discussion, and you're just a wealth of knowledge and tremendous experience. My name is Kevin Muhlendorf. You can reach me at KMUHLENDORF at Wiley.law or find me on LinkedIn. You can find the Triple P podcast on the Wiley website, on SoundCloud, or wherever you get your favorite podcasts. Thank you again for being here. This was a little bit longer, but I think this episode was well worth it, and we look forward to speaking again.